A very
Good
good
morning.
morning, students. Now we'll be continuing with our lecture. In our last lecture, we dealt with the definition of coparceners. What are the incidents of coparceners and what a coparcener can have a right over that particular property. That is what we have seen. We have even discussed one of the right wherein a situation was framed by one of you student and we tried to discuss it. We tried to clear our ideas in respect to that particular right. But I assure you in today's lecture, your ideas would be more clear. And let us see what are the rights of the coparceners. Right? Now, the rights which are actually the coparceners are having are the rights which are actually associated or which are actually attached to the coparcener property itself. That is to say, these are the following 14 rights which are available to the coparcener. Now let us see one by one what these rights are. Right of a common possession and common enjoyment. Definitely, in our last lecture, we have seen that a right which is available to a copartner in a joint family is a right of a common possession and common enjoyment. In our last lecture, we now and then used one sentence which says that no one is having a particular share in the property. Everyone is the owner of the property without excluding the ownership of the other member. That is to say, there is a concept of common possession and a common enjoyment in the coparcenary property. And being a coparcener, one is having a right of common possession and common enjoyment of that particular property. What another right is the maintenance out of the coparcener property. Now, a part of the dependent members in the family, the coparcener too is having a right not only to claim the coparcenary property as a matter of right by virtue of its birth or by the virtue of death of any other coparcener, but even as a but even as if suppose he is dependent over the income of that particular property and hence would be claiming a right of maintenance out of the coparcenary property. So the another right which is available to a coparcener is a right to be maintained out of the income of the coparcener property. The third one is a right to enforce a partition. As we have already discussed, key till the time the coparcener property is there, everyone would be having a common possession and the common enjoyment. But if suppose a person want to have his right separated, then in that case he can have a right to enforce the partition. He can have a right to get the partition of that particular property and can get his separate share in that particular property, the definite share in that particular property. The third one is right to enforce partition, we call the same. Next right which the coparcener is having is a right by survivorship. Because we knew under Mitakshara law, we have an application of both the rules, the rule of survivorship and the successionship. When we talk about the rule of survivorship, then in that case, whosoever is surviving at the time of the death of the coparcener would get the right of the share in the would get a right over that particular property, the ownership over that particular property, which the deceased coparcener was having at the time of his liveliness, that is to say the right of survivorship. So whosoever is survived by the deceased would be having a right to claim over that particular property, though their claim may not be a certain one till the time the partition takes place. So by birth and by the demise of an individual, the survivor's right in that particular property get increased or get decreased. This happens only because of the operation of rule of survivorship. Now, next is right to alienate his divided interest. Right to alienate his divided interest. Divided interest means what? A person's property get separated. He now gets his share divided, and hence, once he get his divided separate share, he is having a right to alienate the same. So once his share is divided, once his interest in the particular property is divided, once he get his own share in the property, he would be having a right to alienate the same as we do when the property is our separate property or is our self-acquired property. In our separate property and our self-acquired property, we enjoy the right to alienate the same. But so far as the coparcenary property is concerned, till the time it is not separated, we cannot alienate that particular share. For the reason our share is not at all definite one. We enjoy the ownership along with the others, accepting the ownership of the other members of the family in that particular property, and hence a right to alienate arise only when there is a divided interest and we get a definite share in the property. Next is right to ask for the account. Right to ask for the account means what we have studied, that under coparcener property or a joint Hindu family property, there is one karta who takes the administration of the entire house, who actually take the decision in respect to the expenses which need to be actually met out in the family affairs. Then in that case, whether that particular karta, whosoever is, maybe the elder member or maybe the educated person, the most educated person, anybody could be the karta, whosoever is actually taking the administration of the house would be considered to be a karta. So here, whatever the karta is doing, every coparcener is having a right to ask for the account of the same. Next is right to set aside the alienation. Right to set aside the alienation means what? Because coparcener's property is not yet divided. And because it is not yet divided, it cannot be alienated by any of the coparcener. But if even though if coparcener alienate the same, if the coparcener alienate the same to somebody, though he cannot alienate, but even if he had alienated, then in that case, that sale or that alienation can be set aside by the other coparceners. Next is right to restrain and unauthorized act. If suppose anybody who is not authorized to do any particular act, if suppose try to do so, for example, if you are just a coparcener, you are not a karta. And if you want to mortgage the particular property, who is having a right to mortgage the property? Only the karta is having a right to mortgage the property. That too for the benefit of the property, that too for the benefit of the people. Then in that case, in that situation, only the karta would be having right and no any other coparcener. But suppose if any other coparcener do so, then in that case, his right, his unauthorized act can be restricted by the other members. That is to say, right to restrain an unauthorized act would be considered to be a right of the coparceners. Then next is the right to renounce. Right to renounce means what? छोड़ देना, अपना right as a coparcener छोड़ देना. अब we have seen that a person when takes birth in the family, he gets a share in the particular property, he gets a right in that particular family property. On the demise of him, his share get distributed among the other members, other coparceners. But suppose if he want to take a sannyas or if he want to become saint, he can renounce, or even if not becoming a saint, but he do not want to have his share, then in that case he have a right to renounce his particular share, and therefore we would consider that it is nothing but a right of coparcener available in order to renounce the share. Renounces a right in the particular property. Now next is a right to make self acquisition. Right to make a self acquisition means what? What do you think? Right to make self acquisition is, right to make self acquisition means what? He can have a right to acquire the same. Suppose if we been not given. Yesterday, one question was asked to me: if a person, if a child is staying with a widow mother, or if a child is staying with a divorcee mother, then in that case, whether the child would be having a right. Then in that case, if the coparcener property is not yet divided, then in that case, definitely the child would be having to make a self acquisition in that particular property. But for that purposes, what he have to ask for? He have to ask for a partition of the same. Then in the and provided again, there must be a clause, there must not be any clause in respect to that so far as the divorce deed is concerned, which has taken place between the mother and the father. So right to make a self acquisition, this right is available to a coparcener. Now next is a right to manage. A right to manage means what? A right to manage the family affairs, right to ask for the account when we are saying right to manage the expenses. This is what whenever a person or the coparcener exercises a right to a right to restrain an unauthorized act of the other people or the other coparceners or the other members of the family, then in that case indirectly they exercise the right to manage. Then right to make a will. If suppose a person gets its separated share in the family property, then in that case only he'll be having a right to make a will. And therefore, if a person suppose, even he can do so, that a person if suppose want to renounce his share, then in that case by making a will he can alienate that particular share. Suppose if given particular share, then in that case he can alienate that particular share to the other family member or the other coparceners or his legal heirs. Now right in the share of income, he whatever the income which is arising in that joint into family or a coparcener property, this particular coparcener is having a right to share in that particular income. Then right against exclusion from the joint family property. If suppose a joint family members want to expel this particular coparcener, भगा देना चाहते हैं इस particular coparcener को, then in that case this particular coparcener is having a right of right against the exclusion from the joint family property. होता है ना, there is a situation wherein a person if suppose get married in some another religion, or if marry with a particular person who been not liked by the joint family members, then in that case they would say you are now removed from the property. So that is not the situation, that could not be done. This particular member would always have a right against the expulsion or against the exclusion from the joint family property. Now students, let us see one by one the points which we have already discussed. The right of common possession and common enjoyment. There is a community of interest and a unity of possession between all the members of family, which devolves upon the other members on the death of any one of them. The other may take by survivorship rule that in which they had during the deceased lifetime a common interest and common possession. The second point says that a coparcener is not entitled to exclusive possession of any part of the coparcener property because the partition has not yet taken place. Each coparcener is have a right to a joint possession and joint enjoyment of the family property. If any of the coparcener is excluded from the joint possession and the enjoyment, he is entitled to enforce his right by declaratory suit. He can file a declaratory suit and can ask for the action to be taken against his exclusion from the joint family property, its possession and enjoyment. Now next one is maintenance out of coparcenary property. The coparcener is entitled to be maintained out of the coparcenary property. The dependent of the coparceners are also entitled to be maintained by the coparcenary property. Yesterday we saw that all the female members like mother, daughter, unmarried daughter, wife, all these are the dependents of the coparceners and therefore they are entitled to be maintained by the coparcenary property, the income arising out of the coparcenary property. If any coparcener and his dependent is refused maintenance, he may file a suit for maintenance out of the coparcenary property. This sentence to the satisfaction of the question which was asked yesterday, wherein it was asked that if the defendant is being refused maintenance, what would be the option? Then in that case, I have already mentioned in the last class that he may file a suit for maintenance out of the coparcenary property. Now next is right to enforce partition. Every coparcener is entitled to enforce partition of his own share in the coparcenary property. If the other coparceners do not consent to partition, then also the partition will take effect. But if a minor files a suit for a partition through a next friend, then the court may refuse to decree the suit if he thinks that the partition is not likely to be for the minor's benefit. Next is suit by the right by the survivorship. The coparcener property devolves by survivorship as we know and not by succession under Mitakshara law. No coparceners can predict his share in the property until he remains joined. His share may increase or decrease due to death or a birth in the family. If any coparcener dies, then his share lapses to the coparcenary and remaining coparceners takes it by survivorship. The coparceners are entitled to get the share of any coparcener who died by survivorship, but of the rule of survivorship is now been limited by Section 6 of Hindu Succession Act, because by the virtue of new enactment, that is to say Hindu Succession Act, the person is cannot be excluded, and hence there is an application of the rule of succession and not the survivorship. Next is right to alienate his divided interest. The coparcener may alienate his own share of coparcenary property subject to the following rules. As we have said that unless and until it is partitioned, it cannot be alienated. Here there are basically three rules by virtue of which the person who is a coparcener can have his own share in the coparcenary property alienated. Firstly, in the state of Maharashtra, Gujarat, Tamil Nadu, and Madhya Pradesh, a coparcener may sell, mortgage, or otherwise alienate for value his undivided share in the coparcenary property, but in the other state, a coparcener cannot alienate his interest for value. Next is the coparcener can alienate his undivided interest of the coparcenary by making a will. Next, when the coparceners secure loan or creditor obtains a money decree against an individual coparcener, he can execute that decree against the interest of individual coparcener in that particular coparcenary and not against the entire coparcenary property. So the coparcener, if suppose he secures a loan and the creditor obtains money against this individual coparcener, then in that case, he can execute the decree. The creditor can execute the decree against the interest of individual only and not against the entire family property. Now next is that is right to ask for accounts. A coparcener may ask for account of the management of the joint property. If a member is prevented to inspect the account book of the joint family business, then he may sue the adult member to prevent them to restrain him from the joint possession and management of the property. Next is right to set aside the alienation. The coparcenary is entitled to set aside alienation made by the father, the manager, or any other coparcener beyond his authority. Alienation is not allowed till the time coparcener's property having the status of coparcenary property. Next, right to restrain unauthorized act. A coparcener may restrain other coparceners from doing unauthorized act in respect of coparcenary property if such act interferes with the joint enjoyment thereof. So students, this was the